All right, we might get underway in the interest of rewarding those that joined very promptly and on time. Just by way of introduction, my name's Richard Basil Jones. I'm the CEO of the Australia-UK Chamber of Commerce, based here in Australia House in London. For those that haven't had the pleasure of coming to Australia House on the Strand, it is the home to all Australians when they're visiting or even when they're living here. A wonderful place. We work very closely alongside the Australian High Commission, Austrade, state trade and investment groups, and other organisations within Australia House. Just quickly, by way of introduction to the Chamber, we're a member organisation, a not-for-profit, independent, and our role is to support companies who are operating here with interests in the UK and Australia. Don't have to be an Australian company, most are. So across our 170 member company organisations, a lot of those, nearly most of those are Australian, but we do have a couple of UK companies as well, including Tottenham Hotspur and Chelsea Football Club, just by way of examples. Today we have part 3 in our setting up in the UK seminars. Parts 1 and 2, which we held back in January, really covered a number of key aspects of the issues facing companies and individuals setting up businesses here in the UK, from tax, VAT, employment, R&D benefits, and also location. Where do you actually set up? Does it, people often think only London. We need to open that mindset up for the opportunities that exist outside of London. So we would encourage a lot of people to go back to our website and have a look at part 1 and part 2 for a lot of those areas, because it covers some of the questions that were asked leading up to this particular webinar. This webinar is part 3, visa and immigration options. And this is an area of greatest importance. It really is a critical piece in the pie from a setting up in the UK perspective. So we have a couple of guest speakers, and I'll provide a brief introduction to them shortly. But just quick in terms of mechanics of the actual webinar itself. 1 hour, we have about 45 minutes of content. There'll be time for questions. There's a Q&A button you'll see at the top of your screen. Please use that if you need to submit questions. We have received questions already, as I mentioned. Your screens are muted. You have a mute, and also we don't see your cameras are disabled as well. So the only faces you'll see will be the actual speakers during the course of this webinar, and it will be recorded. So you will be able to go back and review certain aspects that you'd like to review again. So look, on that note, I'm going to provide an introduction to our first speaker, and that is to Elisabeth Bowes, our Deputy High Commissioner here in Australia House. It is unbelievably valuable to have Elisabeth on this call, because Elisabeth, who started her role here in Australia House in January 2023, was the lead negotiator for the Australia-UK Free to Trade Agreement. And as you'll hear in seconds, Elisabeth will tell you how important this particular area of around mobility and visas was in that free trade agreement. So on that short introduction, Elisabeth, over to you.
Thanks very much, Richard, and thank you again for inviting me to speak and open this seminar. And as Richard said, we partner very closely with the Australia-UK Chamber of Commerce, and we're always delighted to do so, because we do the theory in a way, create the policy, and Richard and his team are very good at translating that then to the business community, so that you can actually understand and take up some of the opportunities that we've created. So as Richard said, I was the chief negotiator of the Australia-UK Free Trade Agreement, which entered into force on the 31st of May 2023. So we're approaching its 2nd year anniversary. And it is really remarkable because it's a comprehensive, very extensive, multifaceted agreement. And it's one of only 3 standalone agreements that the UK has entered into since leaving the European Union. The UK has an extensive network of FTAs, but almost all of those have been rolled over from EU agreements with some updates in some cases, but particularly the Australia and the New Zealand FTAs are standalone from scratch free trade agreements. And that's really a demonstration of our like-mindedness. We're both open, liberal economies. It's also a demonstration of our shared commitment to free trade. And that was highlighted when the negotiations were launched in 2020, in the middle of COVID, and continues to be the case today. We worked very closely with the Chamber throughout the negotiations, and I really do want to recognise the efforts of the Chamber in bringing its members together here in London on webinars, usually at 7 a.m. in the morning here in London and 6 or 7 o'clock at night in Canberra. And those webinars and discussions took place quite regularly. And for me, I found it invaluable because I got the direct feedback from stakeholders on the ground, from Australian companies on the ground in the UK and UK companies about what they were looking for in the FTA. And we'll come to one of the key asks in a moment, because that is, in fact, almost the subject of this webinar. But I just wanted to put the FTA in a little bit of context of the work of the Australian High Commission. We have entered an era in our relationship with the UK where really the breadth and the depth of the relationship is such that we've not seen, certainly since the UK joined the European community back in 1973. Across all areas of policy, be it trade policy, economic policy, migration policy, health, social health. How do we address issues such as Medicare and the NHS? Not to mention, of course, some of the long enduring pillars of our relationship, defence, security and intelligence. So we have two core pillars that we focus on in our work at the High Commission, including the FTA, AUKUS, which has unlocked and will continue to unlock a raft of opportunities for Australian business. But also, how do we support business in investing in the UK in areas such as infrastructure, digital health, the green energy transition, all very key areas of mutual cooperation. As I said, with the FTA itself, it is really an underpinning of our trade and economic relationship. The UK is our second largest investor in Australia and is the second most favoured destination for Australian investment. And since the FTA has come into force, we've seen an uptick in interest by Australian businesses in investing in the United Kingdom. And that includes with our superannuation companies that are looking for those diversification investment opportunities, particularly infrastructure and renewable energy and the green transition. We've also seen an uptick in our exports in goods, and this is one of the probably more tangible outcomes of the FTA, because now trade in goods between our two countries can occur almost entirely tariff-free, and with quotas, in the case of Australia, that will disappear over time. So eventually we will reach that duty-free, quota-free access in terms of goods. And that's particularly important for our agricultural exporters, but not only, for some of our advanced manufacturing exporters as well. And it works in both ways. So we've seen an increase in exports from both countries to each other's countries. We've also seen an uptick in the export of services. Now, that's particularly important for Australia and the United Kingdom because we're both services-based economies. About 70 to 80% of our economy our respective economies are in fact services-based. So what we've done in the FTA is included rules to make it more certain for businesses to undertake that cross-border supply of services, or indeed to enter the UK market. And in some respects, the access for our services providers is equivalent to those enjoyed by European nationals. But all of these aspects that I've spoken about, and there are many more, are often dependent upon the movement of people, be it for a permanent presence here, to set up a branch here, to set up an office to support investment, to support the supply of services, or indeed temporary visits to support that supply of goods, to explore new markets here in the United Kingdom. And this is where the key outcome of the UK FTA comes in. And looking back at some of those conversations I had with stakeholders during the negotiations, the key ask on both sides was to make it easier for Australian and United Kingdom professionals and young people to live and work in each other's country. In fact, some people would have liked to have seen free movement of people, such as we have with New Zealand, but that was not on the table. But what we have done in the FTA is increase the opportunities for business people and young people to live and work in each other's countries. And that's really the purpose of today's seminar. Having created those opportunities, I know Ross is going to talk to you about how you actually take up those opportunities and put those into effect. Just to give you a very quick snapshot of what those opportunities look like. When we look at skilled professionals, for example, intra-corporate transferees between each other's country coming to the United Kingdom can live and work here for 3 years, and their spouses and dependents can also work. In the opposite direction, in Australia, intra-corporate transferees have the right to live and work for up to 4 years. Now, the spouse and dependent work rights is really important because when you have that transfer for such a significant period of time, particularly at that skilled professional level, you're likely to have a family and you want them to be happy and to be settled. So we recognise that the ability for spouses and dependents to live and work in each other's country, along with the main visa holder, was very important. Similarly, specialists have increased access to each other's markets, and young graduates working in different offices can have a transfer, a young professional transfer, for up to a year. So think about a branch office here in the United Kingdom, perhaps a law firm or engineering firm that wants to send one of its young professionals, graduates, for a year's experience in Australia. They can live and work in the subsidiary in Australia and then come back to the United Kingdom, bringing that experience and life experience back to the United Kingdom with them. And that works in both directions. We've also launched something that is quite new and innovative, and that is the Innovation and Early Career Skills Path visa. And this one is a pilot program. It's really quite unique. It is one way. It is from the United Kingdom to Australia in this instance. But what it does is enable those working in fields of innovation, and they're very widely defined. Could be in the creative industries, could be in the food manufacturing industry, could be in the high-tech industry. But those with a recognised experience and track record working in fields of innovation can come and live and work in Australia for up to 3 years without the need for sponsorship. All they need is a contract of employment. And so that's a streamlined pathway for skilled professionals to also take up that experience of living and working in Australia. But probably one of the major outcomes of the FTA, alongside the FTA, was the Youth Mobility Working Holiday Maker visa changes. And these really have been very profound. So in both countries now, the age limit has been extended from 30 to 35, and the time frame for the visa has been extended, particularly in the UK's case, from 2 to 3 years. So in both countries now, young people up to the age of 35, and Richard, not 55, although he would like that, young people up to the age of 35 can live and work in each other's country. for up to 3 years without the need for sponsorship, without the need for a contract of employment. They can enter the employment market. I'm sure Ross will go into some of the visa requirements attached to that, but it really provides a huge opportunity for young people to get that experience of living and working in each other's country, and particularly here in the UK, without any limit in the fields in which they have to work. And in the case of Australia, there is no longer the requirement to live and work on a farm in order to extend the visa for a second and third year, which was really a key ask by the United Kingdom during the negotiations. And just to give you a sense of the uptake of those visa opportunities for young people, in Australia, we've seen UK nationals make up 36,000 working holiday visa applications between July to October 2024, which was close to double the same period in 2023. So there's a very strong interest and uptake by UK nationals of the working holiday maker visa in Australia. Similarly, in the other direction, coming here to the United Kingdom, of the 23,000 people that have come to the UK on youth mobility visas, half of these, almost half, 10,000, were Australians. So we're seeing that movement in both directions. And I know there are many businesses here in the United Kingdom that are really taking advantage of the youth mobility visa to bring over talented Australians from Australia and to work in the Australian subsidiary or office here in the United Kingdom to really help support increasing that investment and market presence. Finally, another area that is so important for the movement of people, which is not the subject of today's webinar, but really should be highlighted, is the increased recognition of professional qualifications. And that's very important also to support mobility between our two countries. Now, generally, mutual recognition of skilled professional qualifications is done by the professional bodies, and we have not changed that. However, in the FTA, we've put a framework around that so that the government drives and encourages the professional bodies to really explore greater uptake of mutual recognition. And in some cases, we can step in at the government level to be a little bit more encouraging from that aspect and bring the professional bodies together. So there's a strong framework, all driving towards increased mutual recognition of professional qualifications, which further supports and creates opportunities for the movement of people. I'm going to leave it there because I know that Ross is going to get into the details of how do you actually take up these opportunities, particularly here in the United Kingdom. But I wish you all the best. And once again, I really want to recognise the Chamber for the initiative in setting up these sorts of webinars, which are incredibly practical, but really help business in taking up the opportunities that we as negotiators have created. And having put in a lot of effort to creating these, I really want to see them taken up for the benefit of everyone. So thank you very much, Richard.
Thank you, Elisabeth. That was fantastic and incredibly helpful framework as to how the Oz-UK Free Trade Agreement was established and negotiated, and the value to everyone. All right, we're into the detail now. So without further ado, I'm going to introduce you to Ross Kennedy, who's the Senior Client Manager at Vanessa Ganguin Immigration Law, and we are going to get into the weeds here. So Ross, over to you.
Thank you very much, Richard. I'm going to start sharing some slides so that people can see what I'm talking about. This will hopefully work seamlessly, technology being what it is. So as Richard mentioned, we're looking at the actual ways of setting up in the UK in terms of bringing people to the UK, a key element of any process starting in the UK. We're going to be starting with a brief overview of the various work visas out there. It's going to be fairly high level because, as already mentioned, there's a lot to cover when it comes to UK immigration, which is why this has a session all of its own. Sponsor licenses are the main work route for the UK, but there are some other alternatives non-sponsored routes, and there are some options which are available for Australians which aren't available for everyone else. And then there are some routes which don't need visas to come to the UK, some activities that you can do, and there are some important pitfalls that you're going to need to avoid in terms of what people do while they're in the UK, and how about you go setting up in the UK. So in terms of the actual visa options that exist, as I mentioned, sponsorship is the main route and skilled worker is the primary route. It is by far the largest and most common route used. And it is a sponsored work visa up to 5 years, potential for permanent residence in the UK. But there are other alternatives out there which it is important to be aware of and consider where appropriate. The scale-up route is going to be good for businesses who are in their early days in the UK. So after you set up in the UK, it's for companies which are in the early part of trading. They're in their growth stage, annualized growth of at least 20% over about 3 years. And it's a very flexible visa. It is a very valuable route if you're able to qualify for it. Global business mobility is another sponsored work route, and it's an important one for people coming to the UK from employment overseas, transfers within the same corporate group, setting up branches and subsidiaries of Australian businesses in the UK. Innovative founder is a non-sponsored route. It's for those people who are creating the businesses, the idea people, the money people coming and actually setting up in the UK, getting the business off the ground. The Youth Mobility Scheme, which Elisabeth has already mentioned, valuable scheme for young people coming to the UK from a limited list of countries, including Australia, which has by far the lion's share of availability under that route. The high potential individual is a route for graduates from top international universities coming to the UK. And the global talent route is for people who are really at the top of their game, the world leaders, Nobel Prize winners, Oscar winners, tech moguls coming to establish business in the UK or otherwise work in the UK. So some important considerations first on what you need to be thinking about even before you actually set up the business in the UK. Do you have any branches or subsidiaries already operating in the UK already? If you do, this can actually close off some routes for you. Some routes require you to have the businesses already operating in the UK. Some of them require that you can't be operating in the UK yet. So think about this early, so that you can decide whether or not one of these routes is more appropriate for you and you can make the best use of it. Don't price yourself out of the market by acting too quickly and setting up too fast. Do you already have UK-based employees? Again, some routes require you to have these in the UK already, whereas other routes, you would bring people to the UK as part of the setup. Do you need to transfer employees from overseas? Are you looking to move people from within the corporate group, or are you just looking for the ability to employ non-British workers more generally? And as I say, if you take certain steps too fastly, are you depriving yourself of any particular options? So early things to be thinking about. There is a UK expansion worker route into the UK, and it is a valuable route, but it can be quite a tricky one to use. You have to be setting up a subsidiary or branch of an existing overseas business, but you cannot already be trading in the UK. So you need to think about this early if you want to be able to use that route. I'll come into more detail on these shortly. But another route to be thinking about early is the innovative founder route for the people setting up a business in the UK, business owners. And the important factor in this is that it needs to be a new business. So if the business is already up and trading in the UK, you can't use it. So again, this is something to be thinking about very early doors before you get too far into the process. As I mentioned, most visa routes to the UK, the most common ones, do require sponsorship. That's sponsorship by a UK employer in most cases. And that employer needs to have a license issued by UK Visas and Immigration authorizing them to sponsor migrant workers in the particular category. There are a range of different sponsorship routes out there, which I'll come on to in more detail. But the general principle behind most of these is that it needs to be a skilled occupation with a minimum skill level attached to it, and there needs to be a minimum salary that's being paid. When you become a sponsor, you take on a lot of compliance duties on behalf of the Home Office in the UK. You'll need to make sure that you are in a position to be able to comply with these. Otherwise, they won't give you the license, or worse, they'll give you the license, let you sponsor someone, and then you only find out after the fact that you're not doing everything right, and they take it away again. Reporting duties are a major aspect of this. You need to be able to make sure you are keeping track of certain events and changes, and you let the Home Office know when they happen. Otherwise, you could find yourself in dire straits when it comes to sponsorship and the visas that are attached to it. You also need to make sure you keep all sorts of records, which are often very good HR practice anyway. You would probably be planning to do it, but some of them are less common, but expected of sponsor license holders. And if you don't keep up with those record keeping duties, then again, that can have an impact on your ability to sponsor workers in the future. And often, if you're not prepared for these duties, you might only find out that something has gone wrong and you're not doing it when the Home Office come round and visit you, often without warning, and go through all your paperwork and files to see if you've been doing it from day one. There's also a general obligation on sponsors that they need to be acting in compliance with wider UK immigration law and other UK laws, such as equality and employment laws. So you need to keep up to date with the changes. It is a moving goalpost when it comes to immigration and sponsorship. So it is important that you keep up on top of any changes as and when they happen. And you need to be acting in a general way, principled way that is in accordance with public values in the UK and for the public good. As I mentioned, skilled worker is by far and away the most common route to working in the UK. It is a sponsored route, so the UK employer needs to have a license to sponsor people in this category. The appropriate skill level for the job is level 3, which is broadly speaking a end of high school level of skill. And it's important to note that it's not necessary that the person has the relevant qualifications for that. It's about the skill level of the job that they're doing. So they might have a lot of experience, but no actual qualifications in it. There is also a minimum rate of pay attached to most sponsorship, and in the case of skilled workers, there is a general threshold since April last year of 38,700, which is pegged at the median rate of skilled work in the UK. But individual jobs in the UK also have their specific going rates, market rates attached to them, and you need to pay whichever is the higher. So if, for example, you were trying to sponsor a junior salesperson and the going rate was below the general threshold, you'd need to pay the general threshold. On the other hand, if you're trying to recruit someone as a sales director or a marketing director, and the going rate was much higher than this, you'd need to pay the going rate. In addition, under skilled worker, there are English language requirements, and the people need to be able to support themselves in the UK. Easy for you guys in terms of English language, because Australians are automatically assumed to be able to speak basic English just by providing their passport. And in terms of personal finances, they can either provide their bank statements to show that they can support themselves once they arrive in the UK, or you as the employer can certify this for them when you carry out the sponsorship. Just to compare now then the expansion worker and the skilled worker routes, because early days of the business, these can be mutually exclusive, and you need to be thinking about this sort of option early on as to which one is going to be the most beneficial for you early doors. Under the expansion worker route, you cannot have a trading presence in the UK yet, whereas under the skilled worker route, you must have an active and trading presence in the UK. So this is why they are mutually exclusive. If you find that you've already set up the business in the UK, but it's not trading yet, then that's okay. You can use the expansion worker. But if you get too far down the process and you've actually started trading, you can time yourself out of the expansion worker visa, which would be unfortunate because it does have advantages to it. In terms of the main qualifying aspects of the expansion worker visa, you can't be trading in the UK yet, but you do have to have been trading overseas for at least 3 years. Or in the case of Australian businesses who are establishing specifically under an aspect of the free trade agreement that Elisabeth was talking about, it can be just trading overseas for 1 year. So there is an advantage there for Australians in some cases. For the expansion worker, your initial employees will be employees of your overseas business being transferred to the UK in order to set up the business here. Whereas under the skilled worker route, because it needs to be an active trading business in the UK, you need to have UK-based people here already who will be responsible for that business. And at least one of those employees or directors based in the UK needs to have settled status in terms of being able to stay in the UK without too many restrictions on their immigration status. The UK expansion worker is, however, intended as a short-term route. It's 1 year initially with a maximum extension to a total of 2 years, with no ability to use that in future. Whereas the skilled worker route is a 5-year visa, up to 5-year visas, with the potential to qualify for permanent residence or settlement after that initial 5 years. The intention of this, obviously, is that you might use the expansion worker to set up in the UK, but anyone who's looking to stay in the UK would really be wanting to transfer into the skilled worker route as soon as you possibly could. So you use the expansion worker route to set up, and then once you are active in trading in the UK, you can apply for the skilled worker license and migrate people across to the new license so they can start accruing their time for permanent residence. The expansion worker route has a higher skill level requirement than the skilled worker route, broadly speaking, graduate level rather than high school level. It has a higher general salary threshold, but lower market rates for the individual occupations than skilled worker. Don't ask me the logic on that. It is what it is. We don't really understand it either. Crucially for businesses in their startup phase, the expansion worker has lower general costs than skilled worker, both in terms of the sponsorship costs for individual workers, and the skilled worker also has an immigration skills charge attached to it, which is a levy which is intended to fund training and apprenticeships of the UK workforce. And that doesn't apply to the expansion worker route. So it is considerably cheaper to use the expansion worker in the short term. And you can sponsor up to 5 people at a time under the expansion worker route. That's the team, as I say, who are looking to come to the UK to get the business off the ground in the first place. One thing to note is if you are using the exemption for Australian businesses under the free trade agreement, where you have to be trading for 1 year rather than 3, you would just be limited to 1 person initially in the UK. But as I say, the idea is that you would, in theory, translate into a skilled worker license over time, and people can stay in that route. And there are no theoretical maximum numbers to the people you can sponsor under skilled worker. If you are looking to set up in the UK and you're looking at ways to do that, you might be looking at skilled worker sponsorship saying, well, this is what I want to have a business in the UK, I want to work for that business, and I want to stay in the UK permanently. The Home Office thinks of this as self-sponsorship, in inverted commas. It's their term that no one really likes because you're not being sponsored by yourself, you're being sponsored by the business. But they don't really like it. They think that it's using the wrong immigration category in many cases. They think you should be using other routes, such as innovator founder, if you're looking to establish a business in the UK, or possibly expansion worker if you're coming to the UK short term just to expand. It is possible to use it, and it really just comes down to a question of how genuine is the situation. They want to be able to see a situation where you're not coming to the UK and you create a business as a vehicle in order to sponsor you as on a work visa. They're looking for a situation where there is a genuine role in the UK. You are coming to the UK for the purposes of running the business, as opposed to running the business for the purpose of coming to the UK. So it is possible to do, but it can be difficult, and it is something that the Home Office is very hot on and in the process of reviewing its guidance. Also important to note that if you are looking to come to the UK and sponsor yourself under the skilled worker route, there is an initial requirement to have a trading business and existing personnel in the UK. So if you're trying to come to the UK and set up the business directly yourself, that could be an obstacle because you need to have boots on the ground already. In terms of the other sponsorship routes, there are several. The main ones that you would want to be looking at really are the Global Business Mobility route, which has several headings. Senior Specialist Worker is the main one. It allows people who are already working for the link company overseas to come on temporary assignments to the UK, as Elisabeth mentioned. That can generally be for up to 5 years maximum, or if they're particularly highly paid, then they can come for up to 9 years in total. But it is not a route to permanent residence, unfortunately. The graduate trainee route allows you to sponsor people who are on a structured graduate training program. They don't need to work for the overseas business for as long as under the senior or specialist worker route, but it is a shorter route. You can generally only bring people for up to a year. And the scale-up route, which I mentioned briefly earlier, is a route for companies in their growth stage. It is a very flexible visa. It has a lot of benefits, but it is one of those harder routes to qualify for because you either meet it or you don't based on your growth. Just to compare the Global Business Mobility route with the main skilled worker route that is the most common, big advantage of Global Business Mobility is there is no English language requirement. That generally won't affect Australians who meet the English language requirement anyway. But if you have other international employees, it's one to bear in mind. There is a higher skill level attached to the roles, generally speaking, graduate level rather than high school level. And there is a higher threshold under the senior specialist worker, same as I mentioned under the expansion worker, but lower market rates. So it can work out as you can sponsor people on a lower salary in some cases under either route, depending on what the role is. One important factor for the Global Business Mobility route is that you can include some allowances in the gross salary. So if you're providing the worker with accommodation or cost of living allowance in the UK, cost of living adjustments, then you can sometimes take those into account as part of the salary package, which you can't do with skilled worker, unfortunately. There are maximum lengths of assignment under the Global Business Mobility route. As I mentioned, generally up to 5 years, sometimes 9 under senior and specialist worker, or up to 1 year for graduate trainee. And as I mentioned, for UK expansion worker, that's up to 2 years in total. Whereas the skilled worker route can be sponsored for up to 5 years at a time, and there are no upper limits at the moment in terms of how many times you can renew that. And often the most crucial factor for people under these, looking at these two routes, is that the skilled worker route counts towards settlement, permanent residence in the UK. After 5 years on the route, you can usually qualify for indefinitely to remain if you meet all the other requirements that apply. But the Global Business Mobility route doesn't count towards that qualifying period. So if people come here initially under a Global Business Mobility route, and then they want to stay, that initial time under the original route can sometimes be wasted. So it's important to be thinking early about what your general long-term options are and intentions are for the workers. Scale-up route, as I mentioned, it's targeted at growth companies. They need to show growth of at least 20% over the previous 3 years in terms of either employee numbers or turnover. And that's generally going to be assessed automatically by the Home Office when you apply based on the records that you filed with HM Revenue and Customs in the UK. The key requirements in terms of the person that you're sponsoring, the role they need to be doing is level 6, as I say, that's generally graduate level. There is a minimum salary threshold of 34,600, or the going rate, whichever is higher. and there is an English language requirement which Australians will meet automatically. The initial visa under the scale-up route is 2 years, rather than being up to 5 years for a skilled worker, but you do have the option for a 3-year extension, and it does lead to permanent residence after 5 years potentially. A key element of the scale-up visa is that it doesn't restrict employment other than in the first 6 months. When you sponsor someone as a scale-up worker, they need to work for you for at least 6 months and can continue to work for you after that for the rest of the 5 years. But they can also undertake any other work. And after that 6 months, they don't have to keep working for you if they don't want to. So it doesn't tie you, the employee, to working for you in the way that the other routes under sponsorship do, where you are only able to work for your sponsor, which can be a disadvantage for you after you've gone to the trouble of sponsoring them. But it does also reduce the level of immigration compliance that you need to be keeping on top of on a daily basis. And it can be seen as a clear benefit to the employee, because the fact that they can leave after 6 months doesn't necessarily mean they will leave after 6 months. And it could be a good benefit to offer them as part of onboarding. In terms of the other global business mobility routes that exist, these are fairly niche, but there is a service supplier sponsorship route where people who are overseas service suppliers in Australia can be brought on temporary assignment to the UK under a contract as part of one of the international trade agreements that the UK has. That includes the free trade agreement, and it also now includes, more recently, the CPTPP agreement as well. There is also a secondment worker route where you're being seconded to the UK as part of a high-value contract, very high value, 10 million per year at least, and not less than 50 million in total. And that's a contract or investment by the overseas employer into the UK. The direction of the investment is very important. Both of these routes are very niche and complex. If you're interested in them, I recommend talking to an advisor. They are tied to specific contracts that need to be approved by the Home Office individually, and they are very difficult and uncommon. Out of over 127,000 sponsored licenses registered for work visas in the UK, there are only 29 service suppliers as of today's date, and there are only 6 secondment worker sponsored licenses. So they are very difficult to use, but if you meet the requirements, they can be very beneficial. So that was a very fast roundup of the sponsored routes, but what about the non-sponsored routes? Are there any of those available? I mentioned earlier the innovator founder route. That's for entrepreneurs and business people looking to establish a new, innovative and scalable business in the UK. The innovative requirement is doing the heavy lifting here. It is the main requirement and the hardest one to beat. This means that you generally need to be making a new offering to the UK market. It's not just that you're going to be making a competitive offering or doing the same thing but better. It needs to be effectively a different approach, a new angle. And there is wide scope to be able to qualify for that, but it can be quite a high threshold to meet that requirement. And the Home Office has said it's not enough just to say, we've got an app for that. We're doing it with an app instead of doing it the traditional way. But if you do meet the requirements, it is a very beneficial route. You need to provide a business plan, submit that to an endorsing body in the UK, and they will assess whether or not they think these 3 requirements are met. And they will decide whether or not you can apply for the visa. Other than that, the visa application is relatively straightforward. It's the first hurdle of the endorsement, which is the difficult part. There is an English language requirement. Again, Australians have it easy on that point. And it can be a 3-year visa initially. You can extend it if you need to, but it is a faster route to indefinite leave to remain and settlement in the UK than most others. Sponsored routes will generally take up to 5 years or longer in order to get to permanent residence in the UK. 3 years as an innovator founder is all you need. Global talent is another major and beneficial route if you meet the very high requirements involved. It is for world leaders in your field. There are different fields available. Research and academia is part of it. Arts and culture, including film and TV and creative sectors. And technology is going to be a big one for businesses coming to the UK. The technology is broadly split into two groups. There's the technical side, the people who actually come up with the tech ideas and the programming and the patents and things like that. And then there's the business management, the business founders, the people who have experience establishing, creating, and running businesses in the tech field. You do need to be endorsed by the relevant body for your particular sector, unless you hold a qualifying prize. But those are really high level. We're talking about Nobel Prize winners, we're talking about Oscar winners and things like that. And the visa can be up to 5 years initially. It can be extended with fairly low thresholds. You just need to be working in your sector, earning some sort of money. And it is a route to settlement as permanent residence in the UK. If you are a current world leader and exceptional talent, then you might be able to qualify after 3 years. Whereas if you are a future world leader, then you may be able to qualify for permanent residence after 5 years in the UK. The high potential individual route is another non-sponsored route based on personal eligibility. You need to have received a qualification from particular universities in the last 5 years. The qualification needs to be at least UK bachelor's level or higher. And you have to be getting that qualification from one of a specific list of universities. That list is updated annually. In terms of Australia, the University of Melbourne has been on the list every year so far. University of Queensland and Australian National University have previously appeared, but don't currently. But if you're in the 5-year window and you've got your award, your degree, at a time when your university was on the list, you can still apply under this route. It is a 2-year work visa generally, or 3 years for doctorate level qualifications, and it lets you do pretty much any work in the UK except as a professional sports person. So you can come to the UK to work for an employer, you can come to the UK to set up a business, but it is not a route to settlement and it's not extendable. So you'll be looking at some point to be sponsored under a skilled worker route or some other appropriate route in order to stay in the UK after the initial visa. We also have family visas in the UK, very flexible if you meet the requirements. It's aimed at spouses, civil partners, and unmarried relationships that have lasted longer than 2 years, generally requiring cohabitation, but not always. And children under 18 of British, Irish, or settled people in the UK, or the partner of the British, Irish, or settled person. There is a minimum income requirement. At the moment, that's set at 29,000 gross per annum. That went up in April last year from the previous threshold. It was due to go up in the autumn, last autumn, and then again early this year. But those increases were put on hold when the new government came in July. And we are currently waiting for the report from the independent migration advisors that the government have asked to look into this as to whether or not that threshold should change any further. In terms of what you can use to meet that requirement, you can rely on employment or self-employment or non-employment, but generally it will need to be the income of the sponsoring partner, the British partner, rather than the Australian spouse who's coming to join them. Or in some cases, you may be able to rely on savings instead. But that isn't just going to be the flat 29,000. There is a multiplier that applies to that because it needs to be able to support you for the duration of the visa. So if you do have savings, those can be from either partner, but there is a higher level to be met. The visas under the family route are 2.5 years of time, and you can qualify for indefinitely to remain after 5 years under this particular route. So for you as Australians in particular, there are some options which aren't available to every other nationality out there. The Youth Mobility Scheme that Elisabeth mentioned is a fantastic scheme for young people coming to the UK to experience life and work in the UK. The general requirements for the Youth Mobility Scheme are that you are aged between 18 to 30, you're from an eligible country, you don't have any dependent children, and you have enough money to support yourself when you arrive. For Australian nationals, you have added benefits. As Elizabeth mentioned, it's increased the upper limit to 35, and you can get an extra 1 year on top of the standard 2-year visa that most people would get under this route. One thing to note is that you can do most types of work in the UK, but there are some restrictions on self-employment and running a business. You can do it, but there are limits on things like how much equipment and you have and the premises you have, number of employees you have. So it is possible, but it is something to be aware of. Unfortunately, it is a one-use visa. You can't renew it. You can't use it if you've already used the Youth Mobility Scheme or you've used the old style working holiday visa that's predated the Youth Mobility. So if you are getting to the end of the potential 3 years under this route and you're looking to stay longer, you would need to switch into another route. And the time under the Youth Mobility Scheme does not count towards permanent residence in the UK, unfortunately. The ancestry route is a wonderful route. It is by far and away the one of the best routes that's available to some Australians. You need to be a Commonwealth citizen, so that's tick for Australia, but you also need to have a grandparent who was born in the UK. So that's the UK as it currently is, or what is now the Republic of Ireland, if you were born before, or if the grandparent was born before 31st of March 1922. And the main requirement is that you want to work in the UK and you intend to work in the UK. That's pretty much it, really. It's a brilliant visa. It doesn't require sponsorship. You can do any work in the UK. It lasts for 5 years, and you can qualify for indefinite leave to remain after that. There are also additional advantages of the ancestry route when it comes to bringing family members with you, which you can do under most immigration routes in the UK. But generally speaking, your family members need to have a minimum amount of continuous residence to qualify for indefinite leave to remain at the end of typically 5 years. The ancestry route, it's much more beneficial. They can join you later, partway through your stay in the UK, and they can qualify at the same time as you. So that there are some distinct advantages to the ancestry route. Some things to watch out for, warning signs and difficult areas of immigration. Hybrid working. Obviously, it's a changed world since COVID, and it's something that the Home Office is getting to grips with. Sponsors generally need to keep track of where people are. You need to monitor their attendance. You need to let the Home Office know what office they're working from. But we no longer need sponsoring employees to tell the Home Office if people are working in a hybrid capacity. In practice, there are still some steps to take, but it's much easier than it used to be. But if someone's going to be working fully remotely, not in the office, then the Home Office will generally require you to justify that in terms of why that person needs to be in the UK at all. If they're not attending the office, why can't they do the job from Australia? Why can't they do it from America? Why can't they do it from Europe? Digital nomad is another big topic that we're seeing a big increase on worldwide in terms of visas and inquiries for the UK. But sadly, we do not have a digital nomad visa in the UK. There is a common misconception that Australians can come to the UK for up to 6 months and do what they want without a visa. But coming to the UK as a visitor has some strict limitations on what you can do while you're in the UK. Visitors can undertake general business activities as well as the usual tourism and things like that. You can attend meetings and conferences, you can attend trade fairs, you can carry out site visits and inspections, you can get information from your meetings for your employment overseas, but then you can't do that work while you're still in the UK. Working, taking employment, providing goods and services in the UK are all considered to be work, and you can't do it while you're physically in the UK. You also can't be paid by a UK source for any business activities you're doing while you're in the UK as a visitor. So if you are working for a UK company, but you're actually living in Australia and they need you to come to the UK for meetings, that generally isn't going to be possible if you're working for the UK company and paid by the UK company, even though your employment is based in Australia. So just some things to be aware of for visitors. It can be complex in terms of what you can and can't do, but it's not a free-for-all that you can come to the UK and do what you want for up to 6 months. Very importantly as well, if you are coming to the UK and you don't have a visa, or you're coming to the UK in a route that doesn't need a visa, such as a tourist or a business visitor, you do now need to have electronic travel authorization. For those of you who are familiar with the ESTA for the US or the ETA for Canada, it works in a very similar way. Australians need to have this to come to the UK since January. It's going to be rolled out to the other countries who don't generally need visas to come to the UK from April. It's a very simple application, generally asking questions about your criminal record and previous immigration history, and it will let you travel to the UK for up to 2 years or until your passport expires, if that's sooner, because it's linked to the passport. Important to note, however, that it is not a visa. It doesn't guarantee you entry to the UK. And if you are refused the ETA, the Electronic Travel Authorization, you do need to apply for that visa to come to the UK. So even though Australians generally don't need visas, you do now need the ETA, and if you can't get an ETA, you do need to have that visa, unfortunately. That comes to the end of my session. So I don't know if we have any questions. Richard?
Yeah, thank you, Ross. And I've got to say, you have covered that incredibly comprehensively and very clearly. And I want to make the comment, I really like the fact that you've assumed that Australians pass the basic English language test. That was a very nice note in your commentary. But in all seriousness, the way in which you framed it, from sponsored versus non-sponsored, expansion worker versus skilled worker, and the various visas under that, was really clear and very thorough. And as I mentioned to start with, this has been recorded and will be on our website for people to review again. We did have a question. You covered, I have to say, a lot of the questions that came in the earlier part prior to the webinar starting, but there was one that we did have that I might ask. The question is, if we move employees from Australia to the United Kingdom, will they get medical, in brackets, NHS, and education benefits similar to British citizens?
So if you're coming to the UK as a visitor, then Australians don't have access to the NHS or education in the UK. There are limits on what studies you can do while you're in the UK as a visitor. If you do have medical treatment while you're in the UK, you would need to pay for it, and there is an uplift on the costs of that, 150% of the cost, I believe. But generally speaking, if someone's coming to the UK under a visa route, then as part of the visa application, they'll have to pay what's called the Immigration Health Surcharge, which is a flat rate in order to enable you to use the NHS while you're in the UK. It works out generally for most routes as £1,035 per year of your visa. So for a 5-year visa, that'll be £5,000 and change. But it lets you use the NHS while you're here. There is a discounted rate as well for children under 18 and for students and for the youth mobility scheme. So that's another advantage to the youth mobility route, is that it means your access to the NHS is cheaper. In terms of education, university fees and so on in the UK, they're not generally based on immigration status, but they are based on residence in the UK. What I would recommend for that is it can get complex, and it's not really something that we deal with on a day-to-day basis. There is an organisation called the Council for International Student Affairs, UK CISA, CISA. They have a lot of information on their website when it comes to international students, international studying, including things like university fees.
Thanks, Ross. There's another question from Emily. How long can you stay in the UK on an ETA, on the new electronic visa? Not visa, not travel authority. Apologies.
Yeah.
Very important point you made. It's not a visa.
And that is the important point. The ETA itself is not a visa. All it does is lets you travel to the UK.
Yeah.
You will generally need to have an ETA when you come to the UK on a route which doesn't need you to have a visa. So the important factor is the route that you're coming under. If you're coming to the UK as a visitor, as a tourist, or for business activities, then generally speaking, you can come to the UK for up to 6 months. But there is an overriding aspect to the visitor route where they say you can't be seeking to live in the UK, and that includes by making frequent and successive trips. They will generally want to know why you're coming to the UK in the first place, what activities you plan to do, and they will make a judgment to the immigration officer when you arrive as to what they think is a reasonable amount of time you would need for that sort of visa. But the general rule is that you can come to the UK for up to 6 months. And with the ETA, you can travel to the UK as many times as you want within the validity of the ETA without having to get a new one. And each time you arrive, you'll be given new permission on entry for up to 6 months. But as I say, careful that you don't spend too much cumulative time in the UK because they'll be looking to see whether they think you're actually living here.
Yeah. Look, thank you, Ross. Look, in the interest of time, we're going to wrap up. For those that are on the call, we're going to certainly make sure everyone has Ross's contact details. What we do find is there are a lot of people that registered for this webinar who actually don't watch it live, particularly because of the time difference in Australia right now, and they will circle back. So we will make sure that Ross's contact details are available to you. And I have to say that we had a case study in one of our earlier webinars, and the point that this gentleman made when he was setting up a small business was that he felt he could do a lot of the activities himself. And he said it was a mistake. He felt that getting specialist advice was not only more efficient, it was far more effective and cost effective. So I'm going to certainly push that point to the people that are on this webinar and viewing this webinar, is that the specialist advice is a highly advantaged route to take. And I think based on Ross's presentation, you'll understand getting experts giving you the right advice is highly valuable. On that note, Ross, thank you for what was a very thorough and very clear presentation. We really thank you for that. And that will be there for our members and non-members as well to access through the Chamber's website. To everyone that joined us, my thanks on behalf of Australia UK Chamber of Commerce, and we look forward to connecting with you at another time soon. So thank you again.